Good morning, everyone. Welcome to the First District Court of Appeals. We have one case to be argued today, which is Ching versus Sims Township. Ms. Hawley, Mr. Solomon, good morning. Ms. Hawley, you may proceed when you're ready.
May I please reserve 4 minutes?
You may, yes.
Good morning, and may it please the court. I'm here on behalf of Yiwei Chang, Jarrett Tucker, 10,007 Bent Creek LLC, Aaron Landholt, and Kristen Landholt, the appellants here. I believe that all of the arguments have been laid out in the briefing well, and I will highlight the points that I believe could be helpful to this panel. To the extent to which there's any questions, I invite them. How was your property being used on June 19th, 2022? My clients' properties were being used as a dwelling unit or portion thereof, which is offered or provided to a guest by a short-term rental owner or operator for a fee for a term of less than 30 days. There's no question here that that is precisely the use that my clients' properties were being put to on June 19, 2022, which is the date of the implementation of G 2022-52, which is the Sims Township zoning resolution restriction at issue here.
And is it your position that because there's no factual dispute about how the property was being used, that's why you believe this is de novo review?
Yes, Your Honor. That is precisely my argument, that you have de novo plenary review over the interpretation of the statute at issue here. So as to how the statute is interpreted, this court has ultimate decision-making authority there. With respect to the facts, there's no factual dispute with respect to how the property was used.
And do we owe any deference to the township as the architect of the ordinance and the one charged with enforcing it about their interpretation?
Well, I will note that has been recent Supreme Court law relating to the interpretation of administrative law, and it empowers the courts with respect to interpreting law. I think this would be a helpful point for me to lay out the roadmap for interpretation of statutes, because I do believe it guides the outcome that my clients are seeking here.
Well, I think part of what I'm asking is an ordinance different than a statute?
No, it is not.
Okay.
And I will point out, just sort of helpful, my friend on the other side of the table and I, we work in administrative law, and in administrative law, a municipality enacts ordinances, a township enacts resolutions. They have the same interpretation with respect to restriction on property owner rights, but they're slightly nuanced. But they are statutes, and they are to be interpreted as statute under Ohio law. And Ohio law is clear. Where a statute is ambiguous, courts must strictly construe restrictions on the use of real property in favor of the property owner. And here, the township cannot establish a unambiguous restriction on my client's property. There is no interpretation.
So you agree that it's ambiguous?
I believe that it is ambiguous. And that ambiguity is to be interpreted in favor of the property owner. The real question that this court is to review is whether the use here falls under the permitted definition of single-family dwelling, which is a permitted use in the zoning district. And I think looking at some of the case law, really the 2 cases that have been presented before the court, it highlights that to the extent to which there's ambiguity, it needs to be interpreted in favor of the property owners.
And what is ambiguous here?
A lot is ambiguous.
Okay.
And I think if you look through the history of the case, it sort of highlights the ambiguity with the township doing everything they possibly can to find some reason as to why they can restrict this property use, notwithstanding the fact that this is a new conditional use restriction that went into effect. It started off that they called it, I believe, a bed and breakfast. That didn't apply. Then they called it a hotel. That didn't apply. They've said that the property is a commercial property, but that doesn't make sense.
But I thought the only issue that you were raising was that the single-family dwelling was ambiguous.
I agree, yes, Your Honor.
Okay.
So that was the question. What is ambiguous about that?
Okay, I appreciate the direction. So single-family dwelling is not defined in the Sims Township zoning resolution. Single's not defined, family is defined, and dwelling is defined. I don't believe that dwelling is at issue here. Really, the question is family. Are the individuals staying at an Airbnb/short-term rental a family? The township cited to the Mara decision, and there's a specific definition for family that was at issue in that case. I would like to just sort of direct the court to it. They define.
Can I just ask
Sure.
real quick, though? Because when I was looking at what the judge's ruling, it seemed like what she focused on was not whether or not it was a family, but whether or not the owners had lived at this property, right?
Yes,
I mean, that seemed to be what her ultimate conclusion was, is that because the owners had never lived there, then it wasn't a single-family residence?
I agree. I agree with Your Honor that that was the interpretation.
Where did that come from, the requirement? I mean, I guess I was confused on where she found that.
I believe, that I understand and interpreted her decision to cite to other definitions for single-family dwelling.
Do they require owners to have occupied the dwelling?
I believe that the interpretation of those definitions could be interpreted in one way to require owner occupation, but frankly could be interpreted another way to not require owner occupation, there being another ambiguity there. And
Okay.
here, the real Achilles heel for that argument is that the township does require owner occupation for some uses. A bed and breakfast requires owner occupation, and they did not put that requirement in a Airbnb short-term rental. That it's simply not required. So it cannot be that a short-term rental requires owner occupation, because if they'd wanted to use those words, they could have used those words.
But we're looking at the use before the change in the law.
That's right.
So whether or not this Airbnb was a single-family home prior to the change, and the judge determined it was not because the owners hadn't lived there.
Yes, that's right. So if single-family residence was restricted to only owner-occupied, then that language could have been used in the definition of family, or it could have been utilized in the definition of single-family.
Okay. All right, but anyway, you were talking about the definition of family and whether you could have a family in an Airbnb.
Yes, that's right. If you look at the definition of family, it's defined by the township as a group of persons occupying a premises and living as a single housekeeping unit, but as distinguished from a group occupying a boarding house, fraternity/sorority house, hotel, or other type of contractual living quarters. So the township is saying that a short-term rental falls within the distinguished other type of contractual living quarters. Our position is that it's, and as a matter of law, would be that a family is a group of persons occupying a premise and living as a single housekeeping unit. I believe the Ohio Supreme Court case of Saunders, which is cited in the briefing, is instructive. In the Saunders case, the court was looking at a foster care facility that was operated to rehabilitate up to 10 youths, the reverend and his wife and their 5 children, so up to 16 people. And my friend is teaching me how football works. I believe that's more than the starting lineup of the Bengals were staying in this house together.
Well, so was there anything in the record about how big these houses are, like how many bedrooms or anything like that?
I do not believe that was
So,
discussed.
I mean, I'm guessing, my question is, like, if they were like a 4-bedroom house, and so you're traveling with multiple families, and you decide to get this Airbnb, and you all pack in there, like, does that change the analysis at all? Is that like more like a boarding house and less like a single-family dwelling?
Well, you're asking interesting questions, and I think they really do highlight that the position the township taking is unfairly ambiguous, because where do you draw the line? If it can be interpreted in more than one interpretation, how can it be interpreted in a way that is clear and leads to one conclusion? I will say that in the Saunders Supreme Court decision, the court noted that nuisance laws, public safety laws would protect against the undesirable circumstances of people not exceeding the building occupancy. Because in that case, one of the arguments of the township was that, well, why can't they put 50 youths? Why can't they put a foster home for 50 youths? What's stopping them? And the Supreme Court said, well, healthcare zoning regulations would step in there to make a difference.
Why can't we just equate an Airbnb to a hotel?
Hotel is specifically defined in the zoning resolution, and the definition does not apply.
Well, because they have to have reception or something.
Yes, that's
Okay,
right.
yeah.
And bed and breakfast, same thing, it specifically did not apply. I appreciate that someone coming into Sims Township who wants to open up a short-term rental today needs to follow the conditional use application process, and I appreciate that now that that's clear. Before the zoning resolution went into effect, it was not. There was not a clear restriction. These are property owners who are trying to make a business for themselves, who have constitutionally protected lawful, non-conforming uses, and we would urge the panel to reverse.
Okay, you're right at your time.
Okay, thank you.
Mr.
Good morning,
Solomon?
Your Honors.
Good morning.
Scott Solomon from Schroeder Mondrell RBR Powers on behalf of Sims Township, BZA, and Sims Township. I'll refer to them as the township throughout. Again, I believe I'm open to questions as well.
Well, let me ask you this then, because the definition, at least if I understand your interpretation of single family, is a single family has to live in the house. Am I correct in that?
I would say that when you buy, if you buy a house in a single-family area, such as the B Residence District in Sims Township, you're expecting other single families to live around you. And I would say that even though it's not specifically defined in the actual resolution, the resolution does provide guidance with respect to Section 31.1, saying that definitions generally, for the purposes of this resolution, certain terms and words are defined and are used in this resolution that are in that defined context. Any words not herein defined shall be construed as defined in the Hamilton County Building Code and in normal dictionary usage.
Hey, let me-
And if you look at the the trial court's decision,
I
the
think- I
last
think Commissioner
definition.
Carter
No,
has a
I'll let him
follow-up.
finish. I'll let him finish. I'll just follow up with you, Scott. It sounded, to me, that was odd that somebody said, or that somebody determined that single family meant that a family had to live there. So what if two friends from college decide to occupy that residence, or a single person lives in it? I mean, those aren't people, aren't families.
And I think
Right?
that family is defined specifically in the resolution. It says a person or groups of persons occupying premises and living as a single housekeeping unit. So two people who are
Living,
friends
okay.
could live as a single housekeeping unit. But as distinguished, it specifically distinguishes from a group occupying a boarding house, fraternity or sorority house, so you couldn't have a
But
college
let
campus.
me ask you this, let's say, I'm tired of my house, I want to leave my house, and so I move to a different house, and I can't sell my house. It's just sitting there vacant for a while. Is that a single-family dwelling?
If it's vacant?
Yeah.
Well, and I guess to finish the definition of family, it talks about boarding house, fraternity, sorority house, hotel, or other type of contractual living quarters. This is the first time I've heard my opposing counsel actually address other type of contractual living
Well,
quarters.
get back to my question. So is my house a single-family dwelling if no one's living there?
I would say it is.
And so why?
Well, the
Because
last time it would have been used would have been you and your family living there.
Okay, so then let's go to this scenario. What makes this scenario different? Because it seems to me the trial court was imposing some sort of occupancy requirement over top of the single-family dwelling concept. And I'm just trying to understand where that came from and how it's applied. Because, like, by her definition, I think my house as vacant doesn't qualify as a single-family dwelling. And that's where I'm trying to understand, like, how do we apply this occupancy requirement that she seemed to impose?
I don't know that she necessarily, I didn't view it as her, I think I viewed it as her interpreting what a single-family dwelling is.
But she was saying that it had to be the owner actually living there.
Well, and I don't think that's true. I don't think that she said that. I think that she said, I mean, she used that as evidence, right? I mean, I think, so in your case, you believe, I believe, they were not using them as, they were not in full compliance with the zoning regulations enforced at that time, is what she said.
But tell me why. That's what I'm trying to get at. Like, why is that the case?
Okay, so if you look before the amendment that defines short-term rentals was
Right.
put in place, you can look at Article 7B, Residence District Regulations. The regulations set forth in that article, or set forth elsewhere in this resolution, when I'm referred to in this article, are the district regulations in a B resident district. Use regulations, a building or premises shall be used only for the following purposes. And it gives a list, a number of different uses that can actually be in a B district regulation. The only one that they even attempted to say was it was a single-family dwelling. And so that's
Well, so
what
going back to what the trial court held, the trial court held that none of these three properties were ever used as a single-family dwelling by the current owners. So as I understand what the court is saying is there is a residency requirement by the owners to make this a single-family dwelling within the definition of the ordinance. Is that not right?
I don't see that. I don't think that I think that you can have two single people living as one unit there. I think you can have a vacant, if it's been used as a residence in the past by a single family or something that falls within the family.
Okay, so let me stop you there. If it's been used in the past by a single family, how can we say that these individual houses have not been used in the past as a single-family dwelling?
I think that they have now changed. They were once residential, but now the testimony from the applicants themselves were that they had no intention of ever living there, that they wanted to use them for commercial purposes. And I think opposing counsel states, okay, now we can't rent it to anybody else. That's not true. You can rent it to other single-family uses, right? You can't have a year lease to a multifamily. If there's two people or three families living in that single family, you'd be in violation at that point.
So you're saying you can still have a long-term rental?
Yes.
So the idea that it was used for commercial purposes, if it's purchased as an investment property to rent long-term, it's okay. So you're allowed to use it for commercial purposes, right?
Well, I don't think that you can use it as commercial purposes if it's going to not fall within the single-family definition,
Well-
family dwelling definition as was
But
required by the
But you
district.
can use it for commercial purposes if you have a long-term rental, right? If somebody
If
just
it's to
purchased.
a single family, if it falls within the single-family
So
dwelling definition,
if these people
yes.
quit using an Airbnb and they decided to rent these houses long-term,
I think that.
Even
we
though it's
probably
for
wouldn't have gotten the
commercial
complaints.
only,
I think I agree
But
with that.
so why, help me understand, why is it okay to do 30 days but not 3 days?
I think it depends as long as it falls within the single-family dwelling aspect of it. You
Well,
can't,
but
a
what
soccer
you're
family
saying-
here is not a family.
Well, but what you're saying is that 30 days does constitute single family, but 3 days does not.
That's not what I'm.
And if I'm wrong
saying.
about that, explain to me why I'm wrong.
I think it just falls within, these houses were being used, rented out, not to single families, to
How do-
different types of people all over the place.
Wait,
And that's in the,
how do we know that?
because it's in the record for the BZA, where that's where you have to give them presumption of validity.
Were
That's
they
basis.
not families?
The soccer families, there were different people, there were different types of people moving in every other time. I think I can read,
they don't have to be related, right? They just have to occupy be a group of people occupying a premises and living as a single housekeeping unit.
As long as they are not a sorority, fraternity, boarding house, hotel,
Right.
or other contractual living arrangements.
So if it
In
was-
in my mind, this would fall within other contractual living arrangement, right? I mean, if I'm going to rent your house for a weekend, that's another
So
contractual.
if it's a group of friends, a group of college friends renting the place for 3 days,
I would say it's other
they're
contractual.
not a family.
No. I would say they're
But
not a family.
but this, all of these things are highlighting what I think is ambiguity based on the lack of a definition for single-family dwelling. And at what point do we not rely on the kind of default rule that we should construe these in favor of the property owner?
I think the default rule is that this court and the trial court may not substitute its judgment for that of the agency if there's, a rational basis. And I think the fact that the trial court has looked at this, and I think that her rationale follows, right? She says, hey, they weren't using these as single family, this was a commercial use, they weren't using these for residential, they were going ahead and renting these out, and they weren't falling within the scope of a single-family dwelling, which was the only 13 of the 13 exceptions that they had to have in place
But I
prior
think
to the
what's
change.
interesting about her definitions is each of the dictionary definitions that she used talks about the premises being designed for use by a single family. And I don't think there's any dispute that these are designed for use by a single family, right?
I think that that's accurate. It was definitely be designed for a single family.
Do you not agree that we have de novo review? Because there's just one issue, is the definition of single family.
Well, I looked at I looked at Judge Shanahan's decision, and I was trying to find, is it a fact that the properties were never used as single-family dwellings by current owners? I mean, I think you could argue that that's a fact that she found, right?
Yeah, and I don't think
That
any.
they were never used as single-family
nobody
dwellings by the
disputes
current
that.
owners. I think that's a fact that she found.
And no
right?
one's disputing that,
Okay.
that the current owners never lived there.
And each property's only been used as an Airbnb, never as a single-family residence
Right.
by the.
Not in dispute,
So I think you have to hold those facts as true.
correct.
Um,
But what about the determination of what the meaning of single-family home is? Is that de novo?
Well, that's where it gets a little tricky, I think, and I believe that's addressed in my brief as well. It talks about the fact that, with respect, and this is binding case law from Nash versus Cincinnati in the First District held back in 2002, that an appellate court of appeals is even more limited in scope with respect to, a review of a 2506 appeal. And that according to the Ohio Supreme Court, the court must affirm the common pleas court unless the Court of Appeals finds as a matter of law a decision of the common pleas court is not supported by the preponderance of reliable, probative, and substantial evidence. And I think in this case, the rationale of Judge Shanahan,
But would you say that's a legal conclusion, though? Determining what the definition of a single-family home is a legal conclusion, right?
I think it's an interpretation that needs to be left to the BZA as opposed to the trial court and the appellate court.
Well, but I think that
And
goes
they, and they
back.
give you guidance on how to do it.
Well,
They
but
submit
that
to
goes
the-
back to my question to Ms. Holly about, do we owe any deference to the BZA as the entity in charge of enforcing these regulations? And if so, what's the legal basis for that?
I would say yes, that, regardless of whether or not there's an abuse of discretion standard or even a de novo standard, that you have to go ahead and apply the same standard that occurs with respect to 2506 appeals in general. That binding case law holds that with respect to 2506 appeals, the BZA's decision is presumed to be valid, and the burden is on the party contesting the BZA's determination to prove otherwise. And I don't think that she's shown that they were legal or in conformance with all of the applicable regulations at that time for a residential Zone B district. As, if they, which one of the 13 does they fall through? She put all her eggs in the single-family basket. And I think that other contractual living arrangements, which is the first time I think I've heard opposing side address that definition, specifically defined.
It's the first time we heard about it all, so.
So I think that is, I don't know how they get around that, because this would definitely be another contractual living arrangement as opposed to a single family. I can't, and we don't know, right? I mean, I think that actually, aside from the testimony where there's been other families, other soccer teams, I think that the evidence shows that it was being utilized for commercial use. I mean, that's evidence that was in the BZA record that the court utilized to come to its decision.
Let me ask you, Mr. Sullivan, just out of curiosity, I don't think it has any bearing on this case, but has Sims Township issued any of these conditional use permits for what I'll call Airbnb rentals? I guess that you, as their attorney, may know or may not know.
I
don't
was,
think it has a bearing, I'm just curious.
I do not know the answer to that, Your Honor, because I don't, I'm not the law director, I represent them via the insurance pool.
Okay, all right.
So I don't know the answer to that.
Okay.
But I know that in the code itself, or since they've made the changes, they've talked about, they address specific conditions like requiring rental property insurance or proper screening, those type of things are conditions that are actually in the resolution that are addressed with respect to, as opposed to now, it's, carte blanche, like they can, rent every other day if you're, I mean, and that's quite frankly how issues popped up, right? It was people living in these nice neighborhoods where they're having problems every week and they've got somebody new living there. Like, imagine yourself, I ask you to put yourself in that position where you live in your nice home and the next week it's sold and all of a sudden there's turnover every week. You don't know who's going to be there. There's, 5 cars, 10 cars. That's not what these people bargained for. And I think it's, I can see the use of Airbnbs, but it's not like.
But not in my
the town-
backyard.
The township is saying, hey, you can't have these. We just want some conditions.
Which makes, I mean, it does make sense, but at the same time, we're talking about whether these owners are grandfathered.
Well, and I think that, the fact that the testimony from them themselves, hey, this was a commercial investment, they never had any intention of using this as a residential for
Right.
themselves. And I think that they talk about family.
But at the
That's
time,
what-
at the time they bought it, it was legal to have an Airbnb.
Well, I don't think it was, see, that's where I don't think it was in.
You don't think
I
it was a
I don't think it was in
single-family
compliance with
residence?
all the regulations
Got you.
set forth that pre-existed that.
Right.
You might think otherwise, but I think that there, and I think, even if you do think otherwise, you can't substitute your own judgment, is also the case. So whether it's an abuse of discretion standard. or
Not if
whether
it's a de
just-
novo review.
Well, I think that I think that you still have to defer to, I think that the decisions of the administrative agency, the BZ. I think the case law.
I feel like the Ohio Supreme Court and the U.S. Supreme Court have pretty much told courts that we don't defer to agencies anymore.
I guess that's, the Supreme Court, I mean, I know with the recent finding, that's
Well, the
probably
Ohio
true. But
Supreme Court has
I'm just
also
talking
made
about,
such a
as of
ruling.
right now, I'm looking at the binding case law that is in existence, the First District, the Supreme Court, State of Ohio. Those are recent decisions that happened only weeks ago. I think that the binding case law here is that deference should be given to the administrative decision.
And you're at your time.
Thank you, Your Honor.
Thank you.
Obviously, we wish that you affirm the decision of the trial court and the BZA. Thank you.
Thank you. Ms. Holly, you have 4 minutes.
I don't know if you were going to get to this, but why is this not another type of contractual living quarter?
So I have no idea what type of contractual living quarter means, and I don't believe it's possible to identify what that means. And I think something that has been touched upon or highlighted is the township is trying to conflate the temporal 30 days with who's staying. They're saying you can't have short-term rentals, you can't have people stay for 3 days, because I'm going to conclude that you're necessarily going to rent to people that don't fall within the definition of family. And that's not right. That's not right under law. There should be no deference given to that argument. If you look at the administrative decision below, the resolution affirming appeal number 2022-06, which is Appendix C to our opening brief, it goes through, well, first we thought that it was a bed and breakfast, but then we decided that it was a hotel. Then we enacted the zoning resolution. However, even though the zoning resolution went into effect after the use began, the language they used was that the subject property was not lawfully being made at the time the amendment became effective, since staff had interpreted such uses as requiring conditional use approval in November 2021. But what conditional use? Hotel and bed and breakfast that they later abandoned? These statutory interpretation issues should not be given any weight, because it doesn't, it's silly, and it does not make sense. If you're looking at this decision, you're thinking, could this also restrict someone for 31 days based upon their interpretation versus 3 days? Then the township's argument cannot prevail. If their argument would just as equally prohibit all rentals, that cannot prevail. The trial court, I concur, or I agree with the interpretation that the judge was imposing as owner occupancy. And it wasn't just that she was finding evidence, she was making a legal conclusion. None of the 3 properties in this case was ever used as a single-family dwelling. Therefore, the initial use was not legal. Because people weren't staying there, she's saying that these are not single-family dwellings. But that runs contrary to the statute, or to the zoning resolution at play here, which does not require owner occupancy. If it did, you couldn't rent a place for 31 days, and that's simply not what was being asked or being requested by even the township itself. The Board of Zoning Appeals testimony from one of the board members said, "We're not telling the individual that you cannot have a rental. We're just saying that you now have new restrictions, 30 days or more, and you can still have your rental." They're trying to conflate single-family dwelling with the term of use. Zoning organizations have the power to restrict through the police power. If there were some kind of parties or uses that were not appropriate under the zoning resolution, they can issue them an order to stop, and they can then enforce the zoning resolution to the extent that it is not a single-family dwelling. But all of the evidence here relates to the fact that they want to stop these short-term rentals, and my clients have established legal non-conforming uses, and we would thank you so much for your time and respectfully request that you reverse. Thank you.
Thank you both for your arguments this morning. The case will be submitted, and we will get a timely written decision. Hope you both have a great day.
Thank you very much.
Court of Appeals, First Appellate District of Ohio is now adjourned.